Hello friends, Namaskar. Myself is Dr. Jinesh Soni. I am an advocate. In today's class, I will discuss an important topic concerning the acquittal in the prevention of corruption at case. I know that it is not easier to fight a corruption case. There might be certain panic to us. But do you think the anxiety, the panic is the solution? If you really want the solution, I request all of you to get up. It's a time to fight for your rights. I know that you are innocent, but you have to prove that you are innocent. For this, we have to study our case. We have to understand the legal position so that we could easily encounter the false anti-corruption case. As we know that in the anti-corruption case, the demand is sine qua non. If demand is not proved, there is mere recovery, mere acceptance. The said scenario could not connect the accused with the crime. So simply we have to understand the pattern of our entry. Regarding this, I will discuss one of the most important judgment of Honorable Bombay High Court. Title is Sudhakar versus State of Maharashtra. Judgment date is 15th of December 2025. In that case, there were three accused persons. Two were public servant and one among them was the private person. To understand the entire scenario, we will take certain examples. In that case, Mr. A was running the fair price shop. Mr. A is complainant. Accused number 1 inter alia communicated with him and inter alia demanded the bribe of rupees 500 per month. At that time, the complainant was confused whether to give the bribe or not to give the bribe. But finally, he decided, I will not compromise with the scenario as per his claim. And inter alia, he abstained to give the bribe. As far as submission or claim, accused number 1 took the undue advantage of his position. He inter alia done the inspection of the premises of him and finally the shop was attached. As we know that when a person is doing his business and inter alia it is stopped by any cause, there might be a panic. Finally, he met with accused number 1. He requested to deattach his shop. Looking to the facts and circumstances, he submitted that the concerned accused number 1 was agreed in lieu of rupees 5,000, which is bribe. And it is decided among them that rupees 1,000 is to be given within 2 days and rest of the amount is to be given after reopening of the premises. In the meanwhile, the concerned complainant means Mr. A approached Anti-Corruption Bureau. This might be our case also. So I request all of you, whenever anyone comes to you regarding his work, there is no need to have any friendly, any formal relationship with him or her. They may implicate you in a false anti-corruption case, and even on their behalf, if a third person is coming, be alert. Simply you have to confine yourself on your work. Otherwise, if there is any talk regarding money, they may connect you or he may connect you or she may connect you with the crime. So I request all of you to be alert. As per the general belief, the precaution is better than cure. Please remember and mark my words. When the report was submitted to the Anti-Corruption Bureau, they have initiated the verification proceeding. Recorder was given, but this time the complainant met with accused number 2. Inter alia, accused number 2 informed that accused number 1 is out of town. And finally, the verification proceeding failed. In the meanwhile, accused number 1 communicated with the complainant with intimation that I had come back. Please come and meet with me. As per claim, the complainant and the shadow witness communicated with accused number 1 At that time, he directed complainant to meet with accused number 2. And accused number 2 directed the complainant to meet with accused number 3 regarding the giving of amount. Accused number 3 is a private person and basically he is the owner of the hotel. He received the amount and finally got trapped. So by the bare perusal of the scenario, it is quite clear to us. This demand by accused number 1 and accused number 2, but recovery and acceptance is by accused number 3. So there is no demand on the part of accused number 3. In that scenario, mere recovery, mere acceptance cannot connect the accused with the crime. But despite of that, the accused persons were convicted. Multiple grounds had been taken to challenge the prosecution. One of the most important ground was that the accused persons were charge sheeted after their retirement. At that time, no sanction was taken. As per claim of prosecution, it is not required, but it is submitted by the accused person that the alleged work regarding which we were charged with section 7 of PC Act is inter alia connected with our official duty. In that scenario, sanction is sine qua non, and if there is no sanction, we could not be prosecuted as per section 7, section 13(d) of the PC Act. And the sanction is imperative even after retirement. They relied on multiple judgments. For instance, judgment of Honorable Supreme Court, citation is 2005 volume 8 SCC page number 130, 2009 volume 15 SCC page number 533. It is submitted that if there is no sanction, which is quite imperative, mandatory, the prosecution of the accused persons is nothing but abuse of process. And Honorable High Court considered that point, and inter alia the benefit was given. As we know that if we are charged with section 7 of PC Act, in that scenario, there will be a presumption of section 20 of PC Act. And to rebut the presumption, we are supposed to raise the plausible defense. And how to raise it? We have to create a doubt in the case of prosecution. And we can do this in two ways. By hitting the prosecution, means by doing the cross-examination, or by submitting our defense. So in that scenario, we could probabilize our submission. For example, A says the bribe was given to Mr. B, and Mr. B says, I have not demanded, not accepted the bribe. But in the plausible explanation, he submitted that the bribe is not recovered from him. It is recovered from Mr. C. So in that scenario, he is going to clog on the existence of the prosecution. And apart from that, during the course of cross-examination, the concerned witnesses give the multiple statements which are inter alia self-inconsistent. In that scenario, we may raise the plausible defense. And apart from that, if there is a case of demand, we have to work out on the electronic evidence. For this, we have to remember in our mind that the guidelines of Honorable Supreme Court verdict, Ram Singh versus Collector Ram Singh, the citation is EIR 1986 Supreme Court page number 3 is quite important. So, if the prosecution totally failed to rule out the manipulations in the alleged record, in that scenario, we could take the benefit. And apart from that, we may attack on the hash value, we may attack on the property, we may attack on the transcription, we may attack on the compliance of section 63 of the BSA. If no demand is reflected from the transcription or from the electronic record, again we take the benefit. For this, we have to remember the judgment of Honorable Bombay High Court, which is pronounced on 27th of November 2024. The title is Dada Sahib versus State of Maharashtra. So, the law is going to support you. It depends upon you in which manner you are going to take the benefit. If you will adopt the non-specific approach, in that scenario, you could not win. You will lose. So, I say, if you are not the solution, you are the biggest problem. So, we have to consider the pattern of our entry, and if we really understand the pattern of our entry, in that scenario, we could exit. But the things are that we have to create the suspicion in the case of prosecution. We have to raise the plausible defense in the case of prosecution in order to be succeeded. Please be noted. And apart from that, if the prime elements are not established, in that scenario, the presumption could not be drawn. In that case, the concerned accused submitted that the case of myself is confined to demand only. And as per the prosecution, the complainant met me at the public place. If I am surrounded with multiple persons, there is no possibility to raise any voice regarding bribe. And looking into the fact and circumstances, the benefit is given to the concerned accused and finally succeeded and got acquitted. So whenever you got trapped in a false corruption case, there is no need to worry. Just read the entire FIR. Submit your submissions, that is called representation. If you are not going to submit, in that scenario, you are going to lose your case. And apart from that, do the complete review. And we have to find out the specific defense so that on the defense line, we could proceed and could do the cross examination and could create the suspect in the case of prosecution. See you in the next video. Till then, Jai Hind, Jai Bharat.